Hello friends, in the series on income tax cases, today we will discuss a case which is based on the proceedings under section 153C. In the present case, a very pertinent issue was before the Honorable Delhi High Court, and the issue was that whether it is necessary to initiate the proceedings under section 153C, that the AO has to establish a link between the incriminating material found in the search of a person with the searched assessee to initiate the proceedings against the other assessee, or in other words, whether the contention of the assessee that the incriminating material do not have any relation with the searched assessee, so the proceedings under section 153C should not be triggered against the assessee, will be of any use to the assessee for quashing the proceedings under section 153C. This issue has been taken up by Honorable Delhi High Court in the case of Shiv Prakash Bansal versus Deputy Commissioner of Income Tax and others, and this case is reported in 486 ITR at page number 316, and the date of the judgment is 18th February 2025. The present case relates to the assessment year 15-16 to assessment year 21-22. In the present case, the assessee has filed a writ petition in the Honorable Delhi High Court against the notices issued under section 153C on the pretext that the material which has been referred by the assessing officer in the satisfaction note do not have any connection with the searched person, so the proceedings under section 153C cannot be initiated against the assessee. As per contra, the contention of the revenue was that for initiating the proceedings under section 153C, what is important is that some incriminating material related to the assessee is found in the search of other person, and that incriminating material should have bearing on the income of the assessee. When the High Court heard the matter, the court said that in the present case, there was no doubt that a search has occurred on some person, and in that search, some cash relating to the other assessee was found amounting to rupees 18 lakh, some jewellery was found, and some details of the locker was also found. Some WhatsApp chat was also found between the assessee and between the searched assessee. So on the basis of this, the assessing officer of the searched assessee recorded a satisfaction note that this material belonged to the other assessee, and on the basis of that satisfaction note of the searched assessee, the assessing officer of the other assessee has recorded a satisfaction note that this incriminating material has bearing on the income of the other assessee. The court said that this exercise is sufficient to initiate the proceedings under section 153C, and the contention of the assessee cannot be accepted to quash the assessment proceedings under section 153C that the incriminating material do not have any relation to the searched assessee. The court said that if the version of the assessee will be accepted, then the revenue will be powerless in those cases where the incriminating material will have no relation to the searched assessee, but it will have a impact on the income of the other assessee. The court said that this cannot be the intention of the law, that the incriminating material should have relation with the searched assessee. What is sufficient is that some incriminating material which has a bearing on the income of the other assessee is found in search of some assessee. Friends, this case is very important because the whole concept of section 153C is that some incriminating material should have been found related to some other assessee in the search of some assessee, but the contention of the assessee that the incriminating material should have bearing or should have some relation with the searched assessee is not justified. So in the present case, the Honorable Delhi High Court didn't entertain the writ petition of the assessee and said that the notices under section 153C cannot be quashed, and the proceedings initiated by the department are well in four corners of section 153C. At the end of this video, once again I am repeating the name of the case. The name of the case is Shiv Prakash Bansal versus Deputy Commissioner of Income Tax, and this case is reported in 486 ITR at page number 316, and the date of the judgment is 18th February 2025. Thank you, friends.